So this is definitely going to be a US-centric approach because the US really just likes its pixel lawsuits. So we're going to spend a little bit of time understanding about these pixel lawsuits, the kind, the type, and then the important part. What are going to be some of the mitigation steps that you can take? And in my opinion, this is actually incredibly important. It is all part of a broader cookie governance. Now, I have lots of cookie references. Cookies are my favorite food. And this whole thing has kind of started with cookies, but the reality is it's around pixels. So you're going to kind of see me mentioning cookies or pixel governance. The whole concept is what tracker are we putting on the site? What is that tracker doing on the site? And that's what this is really all about. So I do have to do a disclaimer. And the funny thing is this is actually typically what I do at the end, but I am not a lawyer. Red Clover Advisors is not a law firm, and we're going to be talking about lawsuits and potential mitigation steps. So I really do need to caveat that this is going to be from the point of view of myself and as a consultant, what I see with companies. I did just come off of the Global Privacy Conference last week. We talked a lot about pixel litigation, and it is just here to stay. So with that being said, let's talk a little bit more. All right, so what's the deal with these digital pixel lawsuits in the US and what are they all about? There's these key legal concepts, they're kind of the ones that are at the bottom, and it's all around, did I place some type of tracker? Am I recording some type of information? Am I literally tracking someone? And did I do it without consent? Now, many of these laws are old. They are old privacy laws that they are using, wiretapping. So the idea and the philosophy is that pixels been placed on the site, information is being gathered about me when I go to the site, and then it is shared to that third party. So that interception of that data transmission happened without consent. Pen register is a little bit about the capturing of outgoing communications. Again, all done without consent. Trap and trace, incoming communications, also without consent. And then a more modern one, but being applied more broadly, is the Video Privacy Protection Act. So the Video Privacy Protection Act was really around videos and being able to, not be able to see all the videos that Jodi had versus what Susie had and share that information. It's supposed to be my video. Well, what's happening is a lot of the trackers are placed inside a video. And so the philosophy is, well, you can see that I watched this video or I played this video. And so they're using that Video Privacy Protection Act to try and apply it to the trackers inside a video. Some of these, in all of these situations, have been successful. Some of them have not been successful. It's a little bit about where the court is, in which state, and even within the state, it's also dependent on the court. What's also really important to understand is at a state level, you also have two-party consent required in a select number of states. That's almost so two-party means both sides have to agree, compared to a single party, which in some states is just me, or actually the company. So the company says, I'm one party, I think we should record, and I just do it. If you've ever called, especially a US company, and waited on hold, and there's a wonderful recording that says, this call will be monitored and recorded for quality purposes. That is part of this consent scenario, and all interconnected. So these lawsuits are all about, you didn't get my consent, you're tracking my information, and you're sharing it to a third party. Who's the third party? Well, it depends on which pixel you've placed. Is it an advertising one, an analytics one, or some other ad tech that is here? All right, where are we seeing this the most? We are seeing it in California, Pennsylvania, Florida, but there are others. The one that gets the most attention is California. It's known as CCPA, the California Invasion Privacy Protection Privacy Act, I think is what CCPA stands for. And you often will hear people say, I got a CCPA letter. I literally have a company last night who just said, I need help. Introduce me to an attorney who can help me with a CCPA demand letter. Now, here's what's really interesting. We also have one of our first CCPA data breach lawsuits due to tracking pixels. So this particular case is very recent, within just this year, and it is alleging in this situation that Capital One uses third-party tracking tools, maybe like Google Analytics and the Metapixel, and it is violating not only CCPA, but also CCPA. Under CCPA, you may or may not know, and as a reminder, CCPA, we have a lot of acronyms like everybody else, but a lot of C's and P's and A's. So CCPA is the California Consumer Privacy Act. That is the comprehensive privacy law in the US, and it was the first state comprehensive privacy law, passed in 2018, effective 2020, with some updates in 2023. If you've ever heard of CPRA, that's actually an amendment to CCPA. That amendment became effective in 2023. So that was your Privacy 101. There'll be a quiz at the end for your acronyms. But in CCPA, there is a provision that if there is a data breach of unencrypted information, there's a private right of action. What this case is trying to do is use the pixels being capturing information, sharing with a third party. That information is likely unencrypted and therefore is a data breach. It has been filed as a class action lawsuit with that private right of action. It's new. We will have to see what will actually happen. If this progresses, I do think you will see the floodgates open with more of these being filed. And you might ask, well, who is doing all of this? There are a number of different law firms. They're called plaintiffs bar. They are plaintiffs firms. They are all about these kinds of, all different kinds of class action lawsuits, privacy just being one of them. And they're the ones that are filing these types of lawsuits or sending a demand letter. We're going to talk a little bit in a moment about these demand letters. All right, so what are the kinds of tracking technologies that are at issue? Well, there's a few. There's targeted advertising. There's also session replay. Those were really hot in like Florida as an example. So session replay might be, I'm going to keystroke everything that's happening on the site so someone else can come along and be able to see what's actually happening on that site. So session replay, being able to replay the actual session. And chatbot providers. This is another interesting one. If you have a chatbot on your site, I get to interact with it. Please tell me your hours. Please help me with this, right? Whatever the chatbot is. Typically, those chatbots are powered by third-party companies, or there's also pixels on that chatbot. Well, when that information is being shared to that third party, if there's no explanation that, hi, I was being shared to the third party, if there's no explanation of a privacy notice, like if there was no opt-in, if there's just nothing, and I just, here's my chatbot and off it goes, there's a lot of different litigation that is happening around these chatbot providers. So think chatbot, it could be just sharing the data to the third party, or it might also have a pixel embedded in it. And then of course, analytics providers. Many of the analytics providers are using this information for compilation to determine who is Jodi, right? Connect it to the rest of my profile. So all of these are some of the really common tracking technologies that are at issue. There could be others that in a future case might come along, but these are the most common that we see. There are, some example scenarios. I've kind of talked a little bit about these, but just to play a little bit more. The first is session replay. This is really common for retailers in e-commerce. So you're going to have retailers, trying to capture what is my movement across the site, what am I engaging with. You're going to also have the chatbot wiretap because my chat is being intercepted by this third party. And another area that is very prevalent is pixel litigation in the health space. This actually gleaned attention at a federal level from the Federal Trade Commission, FTC. And last year, there were a number of different cases, and I envision you might still see some of this, but what was happening was healthcare providers would have a Metapixel or an analytics pixel, or really any kind of pixel, and the data going over was not just person 123, but was also the name of the doctor, or the name of the disease that I was looking up, or the name of the ailment that I was looking up. So health-related information was in the actual, information being shared back to the advertising or analytics company, most often the advertising company. And then that information was now collected by potentially that social media partner who can add it to their entire profile. So the view was this was a breach of information because that might have been protected health information depending on where it was in the journey. If any of you here are in the health space or you work with clients who are in the health space, I cannot emphasize enough, you want to review what are you actually grabbing in that pixel to ensure you are not grabbing a doctor's name, a patient's name, a patient's date of birth, a patient's phone number, or the health condition that is there. That is definitely a no-no. And under some of our privacy laws, it's also going to be a no-no. That is personal health information or consumer health data. Many of our state privacy laws here in the US have this concept called consumer health data, and CHD is specified in some of those laws, and something like this would not be an acceptable use to be able to do that because the consumer health data is considered sensitive information, and in most, but not all, most of the US laws, sensitive health information requires opt-in. So not, it really is any industry, it doesn't matter. I am aware of a IT consulting firm the other day that just received one of these letters, and we have lots of retailers, we have healthcare. The reality is these plaintiff firms kind of don't care who you are, they just want to be able to identify who is out there and what are they doing so that they can grab it. All right, so what exactly happens here? Well, typically, a company gets a letter from a plaintiff firm stating you are in violation with one of the laws, such as CCPA, and it includes some kind of settlement amount. It might be $5,000, $10,000, $20,000. It kind of depends on the company and the situation at hand, but you're gonna get this letter. And then companies have to figure out, great, what do I do with the letter? So my very first recommendation is you need to find your privacy or legal team. If that's an internal person, if that's an external person, this is something that your privacy and legal team should really be the front runners to be able to handle. They should be working with a privacy attorney who specializes in these. I have seen companies who just go to kind of their regular corporate attorney who has no idea what to do, and you really don't want them handling this matter. You want someone who is handling these pixel litigations all day long. They're kind of like bread and butter at this point, and there's a collection of them who know how to handle these for companies. Now, one of the really important things is, what are you going to actually do? Are you going to settle? Are you going to pay? And some companies decide they're going to litigate. Litigation, of course, always comes with a hefty price, but depending on who you are and how important these pixels are, how many sites you have, some companies decide litigation is the course for them, and other companies say, I just want this to go away, and they're going to settle it. And then, if you settle with one, that doesn't necessarily mean you're off the hook because there are multiple plaintiffs' firms, which means then you want to be able to determine what are you going to do to mitigate against other future claims. So to help with that, oftentimes we're moving to explicit consent. You really want to look at your vendor management and understand who are the third parties and what are they doing with this information. We really want to just limit. You want the least amount of trackers on your site because each one might cause a problem. Privacy policy should also be updated. And of course, you want to continue ongoing this because let's say you know, here are my pixels and here's what I have. I've reviewed everything, and then someone comes along and adds a new one. Maybe you're an agency and you're doing this for your clients. It is imperative that you communicate with your clients. I am putting this pixel on the site. The cookie categorization needs to take place. The proper opt-outs need to be there. All of that is part of the governance that I mentioned before and really all part of the strategies. So a lot of times people say, all right, so explicit consent, do I move to explicit consent? Well, let's kind of take a little bit of a step back and first talk about, do I even need a cookie banner? Are they required? Well, globally, and I'm going to kind of pick on my EU and UK friends at the moment. I appreciate we are a global audience and there might be more, but let's just lead with sort of our GDPR. Yes, cookie banners are, we need opt-in. So GDPR requires us to have a legal basis. The legal basis is most often consent, and under our digital marketing regulations, we also need consent in most situations. So we end up with a cookie banner. Know that it's actually GDPR and something called the e-privacy directive or the digital marketing regulation. It's actually not only GDPR. Now, in the US, we're actually not nearly as simple. The reality is that there's not a US law for non-sensitive information. Remember, sensitive information and privacy is not always what we think of as sensitive. Sensitive has its own definitions depending on where you are, and health is included. So let's chop off sensitive over there and just make it plain old normal data. So in the US, our state privacy laws actually don't require opt-in unless sensitive, precise geolocation, and kids data. So if you're targeting Jodi so that I buy more cookies from your bakery, you actually don't need to offer me a cookie banner. You need to offer me an opt-out, a long list of requirements for opt-out. I don't need a cookie banner. So now it's, well, what am I supposed to do with this pixel litigation thing? And remember, I told you I am not an attorney, and it's a really common phrase for a law firm or an attorney to say, well, it depends. And the reality is it depends on who you ask. I have lined up and interviewed and asked this question to dozens of privacy attorneys. And as you might imagine, I get a lot of different answers. It is based on their view of risk. It is based on their comfort with risk. It is based on their interpretation, and it is also based on the business. So what does that mean you should do? Well, some will say move to a GDPR style opt-in. It is the most conservative. It is explicit opt-in consent. And what were all the problems that I was describing? That it was an interception without consent. So if I have consent, you can't argue that I didn't have consent because now I have consent. So woo, easiest mitigation step. Make sure you have opt-in consent and off you go. Others though say, well, if you just have a notice with the ability to manage my cookies, that might be okay. So maybe not the full opt-in consent, but the ability to know that they're here and manage the cookies. But some privacy attorneys feel like this is a little bit of a gray zone and they don't love this approach. And others say, well, it honestly depends on the company and the industry. Because for some companies, and let's use our retailers again, they are reliant on the ability for marketing to draw people to their site, and the ability to not do that anymore might lead to significant loss in revenue. And if I don't have that revenue, which is worse, the lost revenue or paying the fine? And the same might be true with a publisher site where they're relying on the ads revenue on the page. And if people don't opt in and they can't continue to do these things, they're going to have significant revenue loss, then they're going to go out of business, and then there'll be no one to even have a claim against. So for those, they might take the risk of just paying the litigation or the claim if they get it compared to the lost revenue. So just kind of depends on where your business most at risk and from a tolerance point of view. So let's assume we're going to have some cookie consent banners and cookie consent software. And how do we kind of start managing all the different pixels and digital trackers so that we're set up to manage this pixel litigation that is actually happening, and we're going to be in a good place for all the privacy laws that we need to have. So first is you need a cookie team. Who are your privacy and legal professionals? Maybe you're the marketing folks. Who are your people in IT who will help you with this? Who's the owner of your cookie consent tool? Maybe there's a web developer that needs to be part of it. What about an outside ad agency? Maybe you're the ad agency and you need to find the people inside the company who represent the rest of this team. So you got to find your team. These are your people. These are your people who are going to help you, because it's the privacy and legal professionals who really should be the ones advising on what the best course forward is. But to actually make all of it happen, you need your cookie consent solution to work and function. There is nothing worse than having one of these opt-in banners that doesn't actually work. That will not help your cause. Privacy washing here does not work. You have to have a functioning cookie consent solution. And as new websites come on board and new pixels are changing, it all has to get appropriately categorized and again, functioning. So your team is critical to the success here. All right, so let's talk a little bit about some cookie banner do's and some cookie banner don'ts. In your cookie banner, you're going to want to actually explain the kind of cookies you used. You cannot say, hi, we use cookies. That's not a cookie banner. That doesn't explain what you've done. We use session replay cookies. We use advertising and analytics so that we can personalize the experience to you. Here's how you can manage your settings. Click this button, read about our privacy policy. So the single line that says this site uses cookies is not a compliant banner. You really need to have the ability to list the kind of cookies being used. Most of the cookie consent solutions today should allow you to do that. It is incumbent on you, the company, to categorize them and that they're accurate. Our advertising and advertising, analytics and analytics. What is strictly necessary or essential to the site? Remember, essential to the site is not what you, the business, think is essential. It's what is actually essential to make the site work. Don't forget the mobile experience. So from a mobile point of view, don't block my whole thing. So I can't do anything, but I'm forced to accept your cookies. The same is true on a main website. Many times you can't even read the privacy policy because the thing's all over the place. You have to consider the user experience here. And we really don't want our user experience to be horrible on a privacy piece, right? We want it to be good. Provide all the consent options. I can accept, I can reject, I can manage. And the overall rule of thumb is one-click opt-in, one-click opt-out. That is a common piece among regulators and enforcement actions. So I know we're talking a lot about pixels here, but if the banner is hard or the ability to manage settings is tricky and it is hard, then that's not going to help your cause. So the general rule of thumb is one-click opt-in, one-click opt-out. If I can click all, accept all, I should be able to click reject all. And don't forget, you want to make sure that you are disclosing all the cookies here and make sure in your privacy notice that's also reflecting it. Dark patterns. So I have a little bit more on dark patterns, but dark patterns, I will just tell you, I am not well-versed in multiple languages. And there was a website that I went to in a foreign language. I couldn't tell you anything on that page, but I could tell you what the banner said because I knew exactly which button was the far right where it was accept because it was in a darker color, catching my eye and wanted me to click that one compared to the other two. That is a dark pattern. No dark patterns. Regulators don't like dark patterns. Law firms, plaintiffs firms, they all don't like dark patterns either. You're not going to win with a dark pattern. So you need to have the right language. You need to have easy to read font, the same colors. Everything is equal. It's symmetrical. I talked about don't block the page and also forcing me to accept. You will have some that will argue that's not freely given consent. So this kind of goes back to the it depends and philosophy, because if I just say, well, I'm interacting with the site and I'm forced to accept, you're going to have some that are going to say, is that truly freely given? That's a whole nother argument. I'm not going to go with arguing freely given consent at this moment. And then you got to think about how often are you going to need to update that consent. So typically we see at least more frequently than a year. And oftentimes it's more every couple months, because if you think about it, who I was then and who I am now, I might not be in market for the same thing, and the data you had before and the data you have now might not be relevant either. So just a little bit more about dark patterns, because this is such a big deal. I see them all day long. I will tell you that my younger daughter hears me talking about this all the time. She actually takes screenshots at school of all the cookie banners that are horrible. So people actually really care. No misleading colors, no different size fonts. Don't use border boxes around the one you want me to check. Don't have unequal options. Don't use words and language that also make me feel bad, right? If anyone's ever gone to a site and it's, are you sure? You sure you don't want this? Like everything's gonna fall down if you don't pick this button. You don't want language like that in a banner, and you really don't want that language anywhere. That doesn't make your consumer feel good. And guess who's never gonna opt in if I don't feel good about your site? Now, I mentioned earlier, it is critical to test, because if you have a cookie consent solution, you're going to move to opt-in and you don't test, well, good luck. I hope it works out for you. So make sure you have one and you're testing. While I'm here, I'd be remiss if I didn't highlight some of the US nuances, especially under the California law, where we have a do not sell or share my personal information link. Can be swapped with something called your privacy choices. It's a special icon from the Attorney General. Global privacy control. This is the universally adopted universal opt-out mechanism, and the ability to just opt out of targeted ads. Now, all of these also exist in other laws, not just CCPA. but CCPA is kind of the one that started it all. And so if you comply with that one, when it comes to cookies, you're going to be in a good place for the others. But these are unique. So those of you who are a global company, maybe you've complied with GDPR, it does not mean you are compliant with CCPA. We have unique provisions with this global privacy control and universal opt-out. It is where it's kind of the modern day in your browser. I could turn this on with the plugin. You, the site, have to listen for that signal. How do you do that? Your cookie consent solution will be able to help you. Do not sell or share my personal information or your privacy choices is a separate requirement. It's a whole link that has to be on the footer of your homepage to comply with CCPA. Totally different. Can't just be buried in your privacy notice. Now, when you hit the reject button, what do I mean by test? Well, I mean, is GPC working? Is the opt-out actually working? And if I hit the reject button, does it actually reject the cookies? We do a lot of these kinds of audits and tests, and we find all the time that reject doesn't actually work. In fact, we even found one where the opposite happened. They had it set up backwards, like accepted what reject should be doing and vice versa. So these things happen. This is why you test, 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 test. If you learn anything, hopefully you learned a lot today, but testing, walk away with testing. So I hinted a little bit, banner or no banner. That's a really big company decision. So these plaintiffs firms are just going after old privacy laws to say, well, that information was shared without consent. So a lot of people want to have that consent. But then there are other people that say, well, you know, what kind of banner do you really need to have? Does it need to be an explicit? Can it be implicit? Do you even need one at all? Because you have to look at your business model. And then look at where you are regionally. And what do you do about people like me, Jodi in Georgia? Georgia tends not to be one of the states listed from these pixel litigations. Georgia has no comprehensive privacy law. What do you do about Jodi in Georgia? Do I get a banner? Do I not get a banner? Do I get to opt out? Do I not get to opt out? I mentioned global privacy control. That's the universal opt-out mechanism in California, Colorado, and a number of other states. Make sure you are listening to it, turn it on in your cookie consent solution, and don't forget to test. The do not sell or share my personal information. You can see this beautiful little logo here. This is the actual little logo that you can go grab from the Attorney General site. That will help you qualify for your link. It's either you say all these beautiful words here or your privacy choices. Make sure you have the disclosures. Is your privacy notice capturing what you're actually doing? Do you have a cookie policy? And then contracts. Contracts are a whole important part over here because what are the third parties and what are they doing with that information? So to kind of wrap all this up together, I really believe part of the way of how you're going to manage these different pixel litigations, but also enforcement actions, is you have to have a cookie governance program or a pixel governance program. So what are the laws that apply? How are you actually getting it set up? So if someone has a brand new pixel and they want to place it on the site, how does that happen? How does it get there? Who approves it? Can anyone approve it? What kind of information is being collected? Who are these people? So creating this program, who are your people? Remember we talked about the team, the cookie team? Who are your people? Who are your cookie people? What solution do you have? Have you played around with all the settings? Have you tested all the settings? Perform a tracker audit. Now, people always ask me, how often should I do this? It's really dependent on how many trackers you have and how often things change. Are you adding new trackers all the time? Are you removing them all the time? Did your site change a lot? All of those things, because site changes and updates can honestly break a lot of these consent software, in which case the audit and the testing is really important. But if you put on, 2 new pixels a year and your site doesn't change that much, you probably don't need an audit as often as a e-commerce retailer who's changing it every month. Privacy notices are important. Privacy notices are what actually communicate what is happening on your site. Now, train your team. It is wonderful if you, the person listening here, know everything you ever needed to know. I'm guessing because we want a cookie team that you need some other people who also know it is also happening. And you got to manage the program. So today we're talking about CCPA in some of these cases. There's actually a bill in California trying to amend CCPA to say commercial is excluded to try and minimize these suits. We'll have to see what will actually happen. But these firms are clever and they're using CCPA in the data breach. And there will be more that they might come and try to work with. So you got to keep up with all the laws. You got to keep up with these different kind of lawsuits. And of course, what new technology trends are evolving. So in summary, establish a cross-functional team to manage digital pixels, the tracking, and don't forget, remove these, because if you have them and you don't need them, that is not helping your cause here. It slows the site down. You're sharing data with a third party, and it is not helpful from a regulatory or litigation perspective. Get them off your site. Know what you have. So you determine the best way for you to create a comprehensive digital tracker policy and implement these cookie procedures so that no pixel can just randomly show up on the site. Test the banner, build the right banner, build the right opt-out solution, categorize the cookies, test the whole thing, train all the people who should be involved. And then as people are moving throughout the company, that training is going to be really helpful, as well as the policy and procedures. Now they're going to know what it is that they need to do. And then of course we need to audit, because I haven't met a single company that just has 1 or 2 trackers or even 10 trackers and they stay the same, that they never change. I haven't met a company yet. So hopefully you're seeing that it's about people, it's process and technology. Your consent solution by itself doesn't work. Just process doesn't work. It's all interconnected. And with that, I thank you for your time. Here are a couple different pieces for you. So, you got to stay up on top of all these different news. As I shared, I post a lot on LinkedIn. So please follow me on social. And here's just a long list of like oodles and oodles and oodles of downloadable resources. And I really care what you have to say. So here is the QR code and the link for being able to provide feedback. And I think I have time for maybe like 1 or 2 questions. And someone asked about the slides. I will say those are being sent out. Exactly how, I don't know, but I know that they come.
So the best way to get access to the slides is if people fill in the feedback form, and they've got a chance to say what they like, what could be improved, and also kind of thank you for giving such a great presentation. On the thank you page of the feedback form, it has a link to download your slides. So it's basically an incentive for people to, it's kind of like a value exchange in itself, to fill in the form.
Amazing. Well, thank you. And I hope everyone does fill out the feedback form, not just for the slides, but also because Phil and the team spend so much effort putting this together, and everyone here really cares about what you have to share.
Yeah, and I think from my own experience of these kind of situations, a lot of it just takes a bit of information to stop some of these problems happening. Just like some of the things you mentioned there, and it's kind of like I almost, so for some of these brands, well, I bet if they've been hit with one of these lawsuits, they wish they could have fixed it sooner and like solved all the pain that happens after that point. So it's kind of it really does, like I can't emphasize enough the importance of getting an external expert like yourself to come in, check that there's like the defenses around the castle are all kind of up and there's not like a hole in the moat sort of thing.
Absolutely. And Phil, what I'll add is this is external. So any plaintiff's firm, any consumer, any individual, any regulator, they can all see when it comes to these cookies and pixels and privacy notice and all the links that we've been talking about, it's what everyone can see, right? There's some things that are compliance oriented. Those are all internal and they kind of only pop up when there's an issue and a regulator comes and asks, but anyone can go to the website and see what you're doing when it comes to these kinds of trackers. So the audit and understanding what you're doing and testing it is so critical.
Yeah, because it's kind of like evidence-based. So if like one of these attorneys or regulators, if they can run these external tools and see there's a problem, then in effect they can just put that in front of a brand and say, look, I'm seeing these network requests, I'm seeing this, this widget, like for instance, there's the Google Privacy Sandbox widget. I know Privacy Sandbox doesn't exist anymore, but that's actually quite good for seeing what's happening. So it's the same tools actually that we as implementers use, are the similar ones that the regulators are using to kind of for a different purpose. I'm just going to look at the questions in chat here. So someone's asked, should there be 2 different banners, one for web, one for mobile?
No, you don't need 2 different banners. All your consents, unless they're different, but typically people have 1 banner. They might have 2 from a region perspective. So some people will have 1 for GDPR, 1 for the US, 1 for global, one for people like me in Georgia. So not from a mobile web scenario, but more from a jurisdictional approach, if that works for your company. Other people say, I just want 1 because it's just easier.
Maybe that, because I was reading that I think it is CCPA and I found this quite odd. It said it didn't, because the wiretapping, you think about mobile phones or cell phones, but it seemed to focus on desktop connections, not cell phones. Maybe they're referring to.
I mean, they might just be focusing on desktop, but mobile isn't excluded. It's the same. It's the same issue. They just might not have included a good explanation on it. And it is more pervasive on desktop.
Yeah, and I suppose also Apple's a bit more kind of pro privacy, so it's kind of more of a like harder to set cookies and such. I'm just seeing if there's any kind of questions in chat. So people use the Q&A. I can bring up those questions. Christian has asked. There was a mention of not letting the banner overtake the screen. We often add an overlay to force an opt out, whether opt in or out. Is it not allowed in the US? So
I wouldn't recommend forcing someone to do that, because unless you have a reject option there. But if you're forcing me to accept to get to your site, that's not really freely given consent. So that might be frowned upon.
Yeah, I've seen problems, especially with little chatbots, where like the consent banner loads and then you get the chatbot loading up in the side as well. And it should really be the other way around. It's like because users are kind of programmed with banner blindness to just close it and then they see the chatbot or similar. What's that? Yes, there's an opt-out reject. But I think the point of it is that the tool has already started collecting data before a decision has been made. I've got a question, Jodi. Similar to what you were saying in your talk about, you ask 3 lawyers and you get 3 different answers depending on their views of risk, their specialism within business, and whatnot. Like a couple of months ago, I was asking 3 lawyers the same question and got a similar thing. And I want to see if kind of the goalposts have changed a bit. With IP addresses in California, and specifically, I mean, like for instance, like Google deny pins, which happen to have an IP address on them. If someone says don't track me or don't sell to me, are they allowed? Has there been any case law about that? Is it still kind of in the air? Of any of these kind of privacy hawks trying to go after that kind of area? Because like Google got into trouble with tracking on incognito mode in the past. So it's kind of like, okay, someone said don't track me. I know it's kind of not setting a cookie and it's kind of seen as less privacy invasive because you're not identifying the user, but ourselves, we normally try and do GTM server side to try and make it more like bulletproof and more secure. But I'm just curious to know if you've heard, as they shift between different technologies, if they kind of jump from targeting to video to chat to, is the next one going to be deny pings, or like what are you seeing as next kind of tool on the radar?
I haven't seen the next, and nor have I heard anyone talking about it, if I'm totally honest. I think they just kind of keep grabbing at whatever one they can. The video one has been here for a long time. Then the session replay was really hot. Now that was analytics and advertising pixels, and those are still here, and some of the courts have moved along, and there's a lot of settlements that are happening. Companies are just paying. So perhaps, but I can't say I've heard anything in particular.
Yeah,
but I don't think they're going to stop. I think they're just going to keep going.
Yeah, it sounds like it takes almost 1 or 2 years to get one of these brands to kind of defend it, to create case law to stop it from happening almost, and it's sometimes easy for me.
And then there's different courts. So some courts have denied and some courts have let it move forward. There was a big one last year. So we have a global audience here. One of the items just last week was Shopify, based in Canada, was trying to say, well, I'm in Canada, I shouldn't have to comply with the California law. So to, kind of get out of that claim. And the court said, no, it's based on where the people are, not where the company is, which is true for all the other privacy regulations. So if anyone here is thinking, well, I'm not based there, I don't have to worry about it. It is based on where the people are that you're collecting.
Yeah, it's quite common when GDPR first happened, and there are lots of US sites like newspapers that actually stopped European people being able to read these newspapers because of the same reason. is there the point you mentioned about the Senate meeting about a kind of what was it, a kind of an overturning or a commercial reason to
Oh, that's in California. So they're
Yeah.
trying, there are some
Mm.
people who are trying to amend
Mm.
CCPA so that
Mm.
it excludes commercial purposes, in which
Mm.
case businesses would not fall under these claims. And
Mm.
I don't have any new information other than this year they're trying, that is one angle that they're trying to do.
Yeah, I was happened to be reading last night. I've just put the link in chat that they happen to be meeting today, apparently.
Oh.
So maybe we'll find out tomorrow whether
We might.
if things may get a bit easier. But I'm definitely seeing a wave of more brands getting hit with these, and a lot of, as on the consulting side, we're like, it's obviously good for consulting, but the better thing is to try and educate people to stop it from happening. And as you mentioned, make sure the cookie banner is actually working. There's nothing outside consent, and they're in a strong situation, because it's not just the fines, it's the PR and the trust, brand trust, etc. There's a lot of and also that year-to-year headache that potentially could cause. So that's really interesting, Jodi. And I put a link to your LinkedIn profile, so if people want to kind of connect with you later or ask you sort of follow-up questions, obviously, because it's quite a sensitive topic, they might want to just privately talk to you. So I encourage people to do that if they wish to. And I've put your feedback link in the chat as well. So thank you again for speaking, Jodi. I've learned a few things in that which are interesting. I think the other one that I find is people often forget to do the cookie table properly. So it's kind of like they like, it's within the banner and you can drill down into the detail to see it, but they forget to add it to that privacy policy page. And also interesting one, just taking the example of Zoom. So on a Zoom event, Zoom themselves, they've got that little logo in the footer of the site with a little kind of green tick. So I'm actually starting to see that become more of like a standard. So users are kind of expected to know what it means and what it looks like.
That is the your privacy choices. So the little check, the X, it's actually blue. That is from the California piece. That is the equivalent of do not sell or share my personal information. You get that, or the your privacy choices logo. To get the logo and the icon, you have to go to the California Attorney General's site. You get that, and then you still have to add the words. So the way Zoom has it is the correct way of what you're doing. And you're going to see more of those, because that sounds better than do not sell or share my personal information, and it covers you for multiple states.
And just on a last question, Jodi, is there any site where you would say this site, they've done it like better than like a good example to kind of copy?
I mean, the way Zoom has it, and everyone here is on Zoom, so you can see your webpage with the little icon in your privacy choices. That is correct for complying with CCPA. And then in terms of banners, I mean, there's so many different versions of banners. It just needs to describe the kind of cookies that you have. I'm not sure I have a specific site in mind. There's just so many sites. You kind of tune them out after a while, because I've read so many and I pay attention to them, but making sure you're just really clear and here's what we're actually doing, and you have the right buttons, right, that make sense to people. So I've seen some accept only, accept essential, reject. It just, you got to pick the ones that work with your brand and be consistent with them.
Thanks. Someone's got a liquid dice going off in the background. So thank you so much for that. I would I think, as I said, we almost need a list of like good and bad examples for as this education piece to sort of you only know what you know. You get what I mean? So thank you so much. And I said if people reach out to you directly, they can ask those follow-up questions.